make it against the law to draw these districts in certain ways that discriminate on the basis of race, and the court's been willing to get involved in that area as well. But so far, the court has not been willing to get involved when the claim is just, look, there's the same number of districts, we're not discriminating in terms of race, but we are discriminating in terms of party. One party's just discriminating against the other. That's what's called political gerrymandering, and the court just keeps dividing over and over and over about whether to get involved with that. And there's two issues for the court. And one is they're trying to figure out what's the right legal standard. And the second question is, if they can't figure out a good legal standard, is it appropriate for the courts to be getting involved at all? The courts are worried about playing too much of a role in drawing the maps, right? We don't like the map makers. Whoever draws the maps, we get mad at them, right? So if the Supreme Court starts drawing all the maps, we're going to be mad at the court, right? And it's going to be on the court to make sure that the maps are fair, right? 17 years ago, the court decided the 2000 presidential election. If you look at the legitimacy of the court, public polling, my PowerPoint's messed up, but if you look at public polling, after Bush v. Gore, the court took a really big hit in terms of its legitimacy. And for a long time, the court's been considered the most, it's been held in the highest esteem. You ask people, what do you think about Congress, right? What do you think about the court? Pretty respected, right? After Bush v. Gore, the court took a big hit because people started viewing the court as it's kind of a political body. We see this happening right now as President Trump has nominated Judge Gorsuch, and everybody's worried that he's not gonna be a judge. He's gonna be a Republican, right? And so the more that we get courts involved, the more that we threaten the institution of the courts and the idea that courts are not politics, they're something else, right? And so what we need is a very clear legal standard where the court can say this comes directly from the Constitution. We're not making this up. This is what the Constitution requires. And it's really hard because when you read the Constitution, it doesn't say anything about electoral districting one way or the other. It doesn't tell us what the relationship between seat share and vote share should be. It has broad principles, equal protection. Each state is guaranteed a Republican form of government. First Amendment guarantees freedom of speech and other related freedoms. But what the court has to do is take those broad principles and turn it into a clear legal text. And so that's where we are today. I will try to get my PowerPoint up. Okay, so here's somebody who thought the solution was proportional representation and then changed their minds. Here's Idaho. How should we draw these lines, right? Here are some relevant constitutional provisions. So we've got the First Amendment, we have equal protection. But we also have established an independent judiciary. This is hard to see, but that's a salamander again. This is malapportionment, right? And this is the first time that the court started intervening, and the US Supreme Court started telling every state in the country how to draw their maps. Not exactly how to draw them, but putting a limit on how to draw them, right? And the limit, they said, is you can't do this anymore. You can't have these extreme differences in the size of the districts in terms of population. The court struggled with that for decades. People kept invoking the guarantee clause of the Constitution. Do you know what the guarantee clause is? It's in Article 1, Section 4, and it says the United States shall guarantee to each state a Republican form of government. And those Green voters that were all being packed into one district, they said this is not a Republican form of government. When you have a minority controlling everything, it's just not a Republican form of government. And so this violates the guarantee clause. And the court kept saying over and over again, that's not for us to decide. It is a political question, it is not a judicial question. They said it's a non-justiciable political question. which means it's so hard to figure out what the right answer is, it's inappropriate for the courts to try. That's what they did between 1901, as urbanization started and the malapportionment challenges started, and the 60s, the court just kept rejecting these challenges, not saying you're wrong, not saying these maps are okay, just saying it's not our job to fix it, it's not our proper role, it's not clear enough for us to have a legal test, right? And this is Justice Frankfurter, and he has this famous line, courts ought not to enter this political thicket. Courts should not get involved, right? And so it's tough, because we kind of want the courts to get involved, because we don't trust politicians to fix this. But the courts don't want to get involved, because it's a political thicket, right? Now, even Justice Frankfurter was willing to get involved in this case. This is the Tuskegee, Alabama gerrymander. Just when African Americans were starting to register to vote in Tuskegee, they changed the boundaries of the city. It used to be a square, literally a square, just like I drew for you. They changed it into a 28-sided figure like this. And if you look at it, all the white families in Tuskegee still lived in Tuskegee, but somehow all of the black families no longer lived in Tuskegee after this.
Who withdrew?
The state of Alabama. And then a man named Gomillion sued and said this violates the 14th Amendment Equal Protection Clause. And it violates the 15th Amendment, which prohibits discrimination in voting on the basis of race. And even Justice Frankfurter, who didn't want to enter the political thicket in general, said, okay, that's going too far. That the court can stop.
What year was this?
So Gomillion was, this was before one person, one vote. So Gomillion versus Lightfoot, this is like in the late 40s, early 50s. I'd have to check the exact date of it.
Didn't this just happen in North Carolina like last year?
Yes, so in North Carolina, it wasn't drawing the lines differently, it was changing who was allowed to vote. So voter ID, you have to have certain voter IDs. Where the polling places are going to be, whether you're, whether there's going to be early voting, whether there's going to be all those rules about who can vote, right? And we have our chief election officer from Latah County here who has to enforce the rules in Idaho, and she can tell you how important that is in affecting whether people are able to meaningfully cast a ballot or not. What they did in North Carolina is the legislature literally asked their staff, tell us how people vote and break it down for us by race. And then they looked at all the ways that, and these are the findings of the court, they looked at all the types of voter ID that African Americans disproportionately use and said, let's not make, those are not available. What are the ones that white people use? Those are available. And the court found that with surgical precision, that's the line, right? With surgical precision, they were trying to make it harder specifically for African Americans to vote. Now, North Carolina said, look, we are not trying to make it harder for African Americans to vote. We're trying to make it harder for Democrats to vote. That's what they said. They said this is about politics. It's not about race, right? Because the way the court has interpreted the Constitution, if it's about race, the court's going to give a really hard look. If it's just politics, the court's not going to worry about it. And it's really hard because we have a phenomenon in this country that is called conjoined polarization, like Siamese twins, where party and race are very, very closely correlated. They're also correlated with geography, and so people tend to cluster and live next to and have neighbors who tend to be similar to them in terms of both race and party, right? And that's the sort of clustering we need in order to gerrymander, right? But the North Carolina case you're talking about was about who can vote.
Right, okay, I'm sorry. I thought it was similar.
But there's another North Carolina case, which I'm going to get to in 1 minute, okay? And I'm going to come right back to you. Because, so, I think this is 1948, but don't quote me on that because I might be wrong, just Google it, okay? It's Gomillion versus Lightfoot, right? And Gomillion was, he was kind of a cool guy. He was organizing African Americans to register in Tuskegee, right? And one of the rules they had is if you want to register to vote, you need to get a letter of reference from 2 other people who are already registered to vote. So you know what Gomillion did? And Gomillion was like a professor at the university, an African-American professor at the university. He had people working on his house doing like construction work. He said, I'm not paying you until you do a letter of reference so that I can register to vote. And he got his plumber to sign for him, and he got somebody else to sign for him. He started registering to vote. Then Alabama did this, and then Justice Frankfurter said that's going too far. But it was about race, not about politics. And Justice Frankfurter said, we're deciding this on the basis of the 15th Amendment, which deals only with race. We're not deciding this in a way that's going to get the courts involved in politics, right? We should not enter the political thicket. But eventually the court, Justice Frankfurter kind of lost the battle within the court. And the court decided, so Baker versus Carr is 1962. That's the court deciding that malapportionment, having a ton of people in one district and a very small number in another district, the courts can get involved in that. 1964 is Reynolds versus Sims, which establishes the one person, one vote standard. And what that did is it limited the ability of mapmakers to pack voters into one district, right? Because now each district has to be roughly the same size. So we can no longer manipulate the size of districts anymore. But what we can do is manipulate their shape, right? And so what we need now is a rule, a legal test, saying stop manipulating the shape of districts. Yeah?
Do you mean size as an area or population?
Population size. Population size. And when you look at a map, you might see districts that are huge in geographic size because they're sparsely populated. And then a tiny district because it's a city that's very densely populated, right? But in terms of population size, it's going to be roughly the same number of people, right? So now, if you want to manipulate things, you got to manipulate shape on the basis of political affiliation. That's political gerrymandering. And the court is struggling with political gerrymandering the same way it was dealing with malapportionment. So for size, the response of the court was, we're not going to get involved, can't figure it out, we're not going to get involved, can't figure it out. Okay, fine, one person, one vote. For political gerrymandering, manipulating the shape of districts on the basis of political affiliation, not race, right? The court has had the exact same dynamic, where it says we can't get involved, we can't get involved. So the court's addressed this 3 times, and each time the court is deeply divided in very splintered, fractured opinions that are really complicated. But they're basically disagreeing about 2 things. There's 2 questions. 1, can the courts get involved? And 2, if so, what's the legal test going to be? And they're disagreeing on both of those questions. And here's the way it works. Davis versus Vandenberg, can the courts get involved? 6 of the justices say yes, they can. The other 3 say no, they can't, there's no legal test. But the majority said, no, political gerrymandering, that's something the courts can handle. And we're going to apply a legal test. But those 6 justices couldn't agree on the legal test. And so when you read the opinion, it's kind of funny. More conservative justices, Rehnquist, Berger, O'Connor, there is no test. Court shouldn't get involved. These 6 justices, no, the court should get involved, and there is a test. What's the test? Well, Justice White had one test, and then Justice Powell had another test. And there weren't 5 votes for a test. Okay, so people tried for 18 years to bring these claims, and every single one failed. Nobody knew what the test was was too hard, it didn't work. Veith versus Dubiliver, this is 2004. The court splits 5-4 on the question of whether the courts can get involved. The 4 most conservative justices, O'Connor, Rehnquist, Scalia, and Thomas, say courts can't get involved. There's no clear legal test. These 4 liberal justices, Stevens, Ginsburg, Souter, Breyer, they say no, the courts can get involved. There is a legal test. In fact, we have 3 different ideas of what the legal test should be. And they propose 3 different legal tests. And then Justice Kennedy, the swing vote, said, I don't like any of these tests, I don't think they work. But maybe we can come up with a new test in the future. So keep trying, everybody. That's what they did. And people just kept trying. They tried again in Lulac versus Perry, same thing. Liberal justices are like, let's do this, here's a bunch of different tests. Conservatives are like, nope, too complicated, can't get involved. Justice Kennedy's like, I think maybe we're getting closer, I don't know, but we're not there yet. It's been 30 years that the court's been doing this, disagreeing about whether, and if so, how to intervene And for the first time in 30 years, a court has recognized a political gerrymander.